Good morning to all of you. Welcome to Legal Matters by Sai Babu Sukara. Actually, now I am going to discuss a case law on the professional ethics. Of course, now there is no semester for the professional ethics, but since this case has come, when discussing the professional ethics, I will once again enlighten you on the particular topic. Right? The Bar Council of India has set down such standards which are called as professional ethics for all the advocates. Rule number 1, it says, during the presentation of the case, please remember, during the presentation of the case and while acting otherwise, advocate is required to conduct himself with dignity and self-respect. So you must conduct the case with dignity and self-respect. An advocate shall not be servile. Ayya nee banchan dora anakkarledu. And in case of proper ground, he can appeal to the so-called against the judicial officer also. So please remember, the advocate should have the respectful attitude toward the court. Rule number 2. So he should bear in mind the dignity of the judicial office. Definitely, it is essential for the survival of the free or judicial communities. No, please remember, this rule says lowering the dignity of the judicial office will be danger to the judicial system. It is heartening, to be frank, it is disheartening to note that the registrar in charge of the Debt Recovery Tribunal, Tribunal number 1, Kolkata, yesterday they have issued a notice. Yesterday means on 26/7/2022. The notice says like this: due to irrelevant argument made by the learned counsel, luckily they have mentioned learned counsel. Due to the irrelevant argument made by the learned counsel, the presiding officer felt unwell. He got BP. Then, therefore, he returned to the chamber. Hence, the remaining matters which are listed for today, they stand adjourned. What does it mean? So, this is an important aspect. So, please keep up the dignity of the court. No doubt, you must be thoroughly prepared before making the arguments. That's why while the court duty, court attendance topic comes, I have been telling you, please understand the body language of the judge. Suppose if he is not feeling well, if he is feeling frustrated, if he is feeling vexed with your argument, better you stop them. Request the court, Your Honor, can we continue tomorrow? So that is the way we are. But here, due to the irrelevant, irregular arguments submitted by the learned counsel, the judicial officer, the presiding officer, he felt unwell. See how bad it is. Even for telling also is not good. That too it has been put on paper. If it is not put on paper, no doubt we have seen judges who frown upon the advocates, who say that they will take you to the contempt of court, who while the advocate is submitting arguments, try to intervene, and this fellow stops, and to begin once again, he has to go back to the basics. That is another problem. సో మన మధ్యలో ఆపితే మళ్ళీ మొదటి నుంచి ఎత్తుకుంటే కానీ ఆ టాపిక్ దాకా రాలేము ఆర్గ్యుమెంట్స్లో. ఇదొక ప్రాబ్లం ఉంది. అండ్ దే పుట్ ఏ సీలింగ్ లిమిట్ ఆన్ టైం. ఏమండి ఎంతసేపు చేస్తారు, కానివ్వండి కంప్లీట్గా అర్జెంటుగా కావాలని బాగున్న జడ్జి గారు కూడా ఉంటారు. సో డెఫినెట్లీ సచ్ జడ్జెస్ విల్ బి దేర్. ఆఫ్టర్ ఆల్ హూ ఆర్ దే ఆర్ ఆల్సో అవర్ అడ్వకేట్. దే కమ్ జుడిషియల్ from advocate community. They know our difficulties. At least they will be having their own priorities. So this matter he has got so many matters adjourned because there are some other matters. So he might have wanted to get the same disposed quickly. But this man the advocate started irrelevant arguments which are not allowed, which are not agreeable. So normally debt recovery tribunal means definitely the person should have taken a loan from an insurance company, from a finance company or a bank, and he would have become definitely a debtor. So he has to give reasons. Definitely we have to appreciate if he is able to repay the money. Even Article 11 of the ICCPR, already I told you that a person should not be arrested for failure of the contractual obligations. But there is a way to express your opinion. That's why please understand the body language of the judge also sometimes. Otherwise, things will be like this. Anyway, this is a classic bad example of professional ethics where you have to give respect to the judge. But since because of the irregular arguments, the judge felt fatigue, felt unwell, and he has retreated to his chamber. Ultimately, the other matters were postponed, adjourned. So, will they not curse you? Will they not curse the learned counsel for making the judge? Of course, if you ask the concerned counsel, he will say that I have to satisfy my client or there is material before me, like that he will say. But anyway, so as a professional ethics class, you as an advocate, you have to learn that. Please remember, while submitting the arguments, you must make only relevant arguments, you must be dignified, and you must maintain respect to the court. With this, I want to say bye. Thank you very much. Friends, just now, I have spoken to you regarding the professional ethics and also advised you to submit the relevant arguments by being prepared well in advance. Taking example for the Debt Recovery Tribunal number 1 of Kolkata. But a little later, I found in the WhatsApp that the Debt Recovery Tribunal has given another letter. I think we can say that it is a corrigendum, saying that the earlier notice issued today, that is on 26th, yesterday, July 2022, it stands withdrawn. Due to unwellness of the presiding officer, the remaining matters listed today, they stand as adjourned. So now, in a jocular way, we can say that it is nothing but comedy of errors. In the first notice, we don't know who has taken a photograph of the same by that day, because a copy of it was sent to Bar Council, like that it has been copied to, it was mentioned like that. But after a little later, the rejoinder has also come. Good. Now it is clear that due to the unwellness of the judge, all the matters have been posted. Of course, I am happy to note that the lecture given by me for about 5 or 6 minutes is really a waste, because the advocate definitely would have submitted the relevant arguments only. But whatever it is, as students, you have to know that you should not cause headache to the judges. Anyway, so these 2 letters, if you go through they can find, search the Google, 2 letters will be found. Anyway, it's a happy ending that not because of the advocate, but because of the health problem, the matters have been adjourned. Of course, next day, that is today, they will be taken up. So this rejoinder may also be read with my first video. Of course, both of them will come in the same video. So first part is, I have given maybe a boring lecture to you that you should be submitting only relevant material. I have definitely would have commented about the advocates also, but since the rejoinder has come, we must feel happy. It's a happy sign. Okay, thank you very much.